Hello friends, in the series on the income tax cases, today we will discuss the case of Vyada Sounds versus Principal Commissioner of Income Tax, and this case has been reported in 444 ITR at page number 428. This case has been decided in the writ petition by the Kerala High Court and the date of the judgment is 24th March 2022. The logic for discussing this case is that this case is the perfect example that how the income tax department is indifferent with the request of the assessee, which is legitimately made by the assessee by using the well-established principles of law. In this case, the title documents of the properties of the assessee have been retained by the department for 22 years and they were not handed over to the assessee by giving either no answer or by giving vague answers which are not as per the law. In this case, the search was conducted on the assessee in 2001. The assessment proceedings were completed. The assessee moved to the CIT appeal, then ITAT, and the High Court gave the relief to the assessee that only the 25% of the additions will sustain. The assessee was before the Supreme Court in the special leave petition. In the meantime, when this process was going on, when the assessment proceedings were completed under section 153A or you can say 158, the assessee made a number of the applications to the department for release of the seized documents. But the department didn't even bother to reply to the submissions of the assessee, to the applications of the assessee for the release of the documents. The assessee moved an application under the Right to Information Act 2005 and at the end the assessee got a reply from the department that since the proceedings are pending before the Supreme Court, since the SLP is pending before the Supreme Court, that is why according to section 132 subsection 8, your seized documents cannot be handed over to them. So in this case, the pertinent issue is that whether as per section 32 subsection 8, whether the SLP pending before the Supreme Court can be termed as proceedings under the Act. There are provisions of section 132 subsection 8 which says that as far as the assessment is completed for the such cases, the documents cannot be retained by the department beyond 30 days if the reasons are not recorded and if the approval of the principal commissioner is not taken. Although there is no mention in the provision that whether these reasons or this approval which has been taken from the principal commissioner is to be handed over to the assessee, but the Supreme Court in one of its judgments said that because the interest of the assessee are prejudiced when the seized documents are retained by the department, so following the principles of natural justice, the reasons recorded and the copy of the principal and the copy of the approval from the principal commissioner should be handed over to the assessee. In this case, when the writ petition was pending in the Kerala High Court, the department was not able to keep on record the copy of the reasons recorded and the copy of the approval. In fact, the department after 17 years gave some document to the High Court on which there was no DIN number for the approval taken from the principal commissioner. So, in these circumstances, it cannot be said that the reasons have been recorded by the department and the adequate approval has been taken from the principal commissioner. And there is proviso to section 132 subsection 8 which says that even if the approval is being taken, then when the proceedings are completed, the seized documents cannot be retained by the department for more than 30 days. Because in this particular case, the proceedings were completed as far as the judgment of the High Court came in favor of the assessee. So, the document should be handed over to the assessee within 30 days from the date of the order of the High Court. So, in this case, the court said that if the appeal is pending, if the SLP is pending before the Supreme Court, then it cannot be said that the proceedings are pending. And the proceedings were stopped at the time when the judgment of the High Court came. So, the department was at fault in retaining the copy of the, or you can say the registry or the documents of the properties of the assessee without the authority of law, and the court ordered the department that all the documents should be handed over to the assessee within 30 days from the date of this order. Friends, this case is very important because as soon as the assessment is completed, it is the duty of the department to record the reasons, to take the approval of the principal commissioner, and then give this copy of reasons and approval to the assessee that why they are not returning the seized material to the assessee or the seized documents to the assessee. At the end of this video, once again, I am repeating the name of the case. The name of the case is Vyada Sounds versus Principal Commissioner of Income Tax, and this case has been reported in 444 ITR at page number 428. The matter has been decided by Kerala High Court and the date of the judgment is 24th March 2022.